I'm Nick Brooks, a California employment law attorney. Did a former employer give you a bad reference that cost you a job? That might be illegal blacklisting under California law. Today, I'm breaking down Labor Code Section 1050. So, what blacklisting is, how it's proven, and the serious penalties employers face for preventing former employees from getting work. First, what is blacklisting? Well, California Labor Code Section 1050 protects workers from blacklisting by former employers. After employment ends, it's unlawful for an employer or its agents to make misrepresentations to prospective employers that prevent or attempt to prevent a former employee from obtaining new work. Violations can result in both criminal and civil liability. To win a blacklisting claim under Section 1050, a former employee must prove 6 elements. First, the employer made a representation to a prospective employer after employment ended. Second, the representation was untrue. Third, the employer knew it was false at the time it was made. Fourth, the statement was made with the intent to prevent the employee from finding work. Fifth, the employee was harmed. And sixth, the employer's conduct was a substantial factor in causing that harm. Section 1050 applies only to misrepresentations made to third party prospective employers, not internal company remarks. Truthful, good faith communications requested by potential employers are generally privileged under Civil Code Section 47C, provided they're not malicious or reckless. Knowingly violating Section 1050 is a misdemeanor offense. Aggrieved employees can recover actual damages, which are subject to mandatory treble damages under Labor Code Section 1054. That means triple your damages. Plaintiffs must choose between statutory treble damages and punitive damages. You cannot get both. Here's how California employers can avoid blacklisting liability. First, provide only factual, accurate, and non malicious references. Train supervisors and HR to avoid misrepresentation. Restrict reference responses to authorized personnel and use neutral reference policies. Keep detailed records of all communications with prospective employers. And stick to verified facts like job title and dates of employment, not subjective opinions. California strictly prohibits employers from interfering with former employees' future employment through misrepresentation. The law protects workers from blacklisting and carries significant criminal and civil penalties for violations. For more information about this legal issue, please visit the blog and my website at nickbrooksesq.com. That's nickbrooksesq.com. And please subscribe to my YouTube channel for more California employment law tips. Thank you very much.